Employment Law This Week. I'm George Whipple. Our top story, a federal court in Texas has temporarily enjoined the Department of Labor's new exemption rules. The rules, which would have dramatically increased salary thresholds for overtime exemptions, were set to go into effect on December 1st. The district judge found that the 21 states who brought the suit established a prima facie case that the DOL overstepped its authority in establishing the new rules. Because the Fair Labor Standards Act makes no reference to salary thresholds, the court found that any new thresholds might have to be created by Congress and not the DOL. If the injunction is made permanent, it could be the beginning of a lengthy appeals process, which would leave employers in limbo. Jeff Ruzal has more.
It's important to keep in mind that the court's decision is only a preliminary injunction, which means that litigation will likely continue in earnest. Employers should carefully consider any additional changes they make. There are significant employee relations concerns in scaling back any changes they've already communicated to their employees. It will certainly hurt morale, and it may even lead to questions from the employees as to whether they were misclassified incorrectly in the first place or whether they have some legal entitlement to that additional promised money.
While overtime expansion is stalled at the federal level, New York State's plan to increase salary thresholds remains on track. Under the rule, thresholds for overtime exempt employees will rise to $825 per week for large employers in New York City and $787.50 per week for employers in Nassau, Suffolk, and Westchester counties. If the state's Department of Labor proceeds with the new rule, it will go into effect on December 31st of this year. The EEOC releases updated guidance on national origin discrimination. The new guidelines address legal developments on issues like human trafficking and harassment in the workplace. The guidance includes over 30 examples of national origin discrimination, as well as best practices to reduce the risk of violation. It also states that if an employee's accent materially interferes with his ability to communicate in spoken English, and that is a job requirement, an employer can legally move that worker. The USCIS has issued a final rule that makes it easier for employers to sponsor and retain skilled foreign workers. The rule gives added job flexibility and protection to foreign workers in the H-1B status, or who are stuck in the long green card application process. It also expands eligibility of certain employers for H-1B cap exemptions and adds grace periods so certain skilled workers can remain in the country for limited periods while in between jobs. Last week, as part of the 21st Century Cures Act, the House passed new mental health reform legislation intended to step up enforcement of rules requiring that insurers cover mental health care at the same level as they cover physical health care. This could impact employers' health insurance plans. For this week's Tip of the Week, James Gelfand, Senior Vice President of Health Policy for ERIC, is here with some advice on how employers should update their plans in 2017 in order to remain compliant.
Put in place a robust process to respond quickly and authoritatively to questions about non-quantitative treatment limitations. Be aware that the regulatory agencies will be charged with significantly stepping up enforcement and auditing, issuing an expansive new compliance guide, and putting in writing examples that should help ensure your plan design is in compliance. And clarify the process for eligible individuals to obtain plan documents, parity and claims information, and answers to coverage and payment questions, both internally and externally. A provision of this law will clarify that eating disorders, if covered at all, are included in your plan's mental health parity requirements. This clarification will become effective immediately upon enactment of the bill. Employers should take steps to update their insurance plans in time.
Thanks, James. That's it for Employment Law This Week. Thank you very much for watching, and we'll see you next time.